Hi, on behalf of the UKSLSS, welcome to the grand finals of the UKSLSS-A&G Annual Moot 2023. Welcome to those of you with us today in the audience live, and welcome to those of you who will be watching this subsequently on YouTube or on our website. Today we have two teams, the Appellant from the University of Cambridge and the Respondent from the London School of Economics. With us today as judges, we have Stanley Lai and Ramesh Salvraj from Allen and Gladhill. So a brief introduction to the path that's led us here. Through a series of written submission rounds, preliminary oral rounds, and semifinals, and now the finals, we've whittled down 20 registrant teams into just 2. And that's what we have for you today. So, judges, if you are ready, in the case of Mo Shengren Private Limited and Beanstalk Enterprises, we will hear argument from the senior appellant.
Yes, good morning. Please introduce yourself, counsel, and begin your arguments.
Good morning. Before I begin, can I just clarify that everyone can hear me?
Yes.
I can hear you loud and clear.
Thank you. I'll begin shortly. May it please the court, I am Ning Teoh and I appear for the appellant, Beanstalk Enterprises Limited. Today I will make 3 submissions in support of the first ground of appeal. My first submission is that there should not be a duty of good faith to be implied in law. My second point is that neither should there be a duty of good faith to be implied in fact either. And lastly, I will submit policy arguments to show why finding a duty of good faith in this instance will undermine the spirit of contractual relations. My first point is that there should not be a duty of good faith to be implied in law. Tabar J himself acknowledged in his judgment that he was guided by the principles of English jurisprudence, which I agree with, and it is important to note that English law adopts a piecemeal approach to the doctrine of good faith, and this means that it cannot be applied widely. Gap Horn emphasizes that implying good faith involves policy considerations, and that is a further reason for caution. Given the fledgling nature of the doctrine, with disagreement on the very theoretical nature and philosophical basis of good faith, I submit that it's very important to set a high threshold to be met before good faith is implied in any instance. And in the present context, there's no extreme circumstance that justifies a finding in law. Importantly, one of the only prominent English cases in which a duty of good faith was found was Bates, where this involved contracts with a public authority and employment, and this cannot said to be analogous to the present case. My second submission is that good faith cannot be implied in fact either. And the criteria for finding a term implied in fact more generally can be found in Yam Singh at 132, which identifies 2 criteria. Number 1, the term is so obvious that it goes without saying. And number 2, the term is necessary to give business efficacy to the contract. And neither criteria is fulfilled in this case. Specifically, I found that it wasn't the case.
Counsel, why do you say that? I mean, I'm looking at the trial judge's decision at paragraph 25, where he actually says, looking at the facts of the case, that this case was quite possibly the best possible example for finding a duty of good faith in fact. And he cites the long-standing course of conduct between the parties as evidencing a relationship of mutual trust and confidence. What do you have to say to that? I mean, clearly there appears to be a finding by the judge on the facts of this particular case.
Yes, Your Honor. I understand that is what the judge said. But I also submit that it's very important to bear in mind other features of the contract and not to determine that just because of the long-term nature of the relationship, that must mean that there's an exceptional relationship to be found.
So what are these other features of the contract that you say sort of counterbalance?
I would say that other features of the contract are firstly the non-exclusive nature. There's no exclusivity clause. That means that my client is free to pursue its own alternative partnerships to that end. Secondly, yes, the parties were in a long-term relationship, but there was also a provision for the parties to withdraw from the contract with 3 months written notice, which is quite a relatively short period of time. So I would say that although it is a long-term contract, this signals that the parties are not willing to have significant financial commitments and they're able to recuse themselves anytime, right? So it wouldn't be detrimental if they did so.
But the termination clause, the one that you've cited, is fairly boilerplate. It's fairly standard. You see that in many contracts. So the mere fact that there's a clause providing for termination with notice, why should that change the complexion of things? I mean, what the trial judge appears to have done is looked at the underlying relationship between the parties, and he's clearly noted that this is a situation where you've got two contracting parties that have been doing business with one another over an extended period. And that's clearly played an important consideration on the judge's mind in finding that at the very least should be an implied duty in fact.
Yes, Your Honor. As you've pointed out, this is quite a standard clause. So my submission is that perhaps it doesn't show that the relationship between the parties was shallow, but rather what I'm trying to argue is that the relationship shouldn't be construed to be exceptional. And given how there's disagreement on deduction of good faith, as I've argued, I think there needs to be a very high bar.
So what can you give me an example of an exceptional relationship which might call for a implied duty in fact? I'm just trying to understand, because you said it wasn't exceptional, right? So can you give me an example of what might be an exceptional scenario which might invite a finding of an implied duty in fact?
Yes, Your Honor. What would it be an exceptional circumstance would be if there was exclusivity. The partners were in an even longer relationship. There was even more significant financial commitment, because if you look at the terms of the contract itself, the preamble, it says that the partners will work together, have regards to partnering principles, blah, 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 with a view to achieving mutual equitable profits in good faith. So I would say the counterfactual is an even more exceptional relationship would just delete the mutual equitable profits entirely. They would agree to work together in good faith in the spirit of the joint venture. Because
also, can I ask you, what is the effect of these preambular paragraphs in a contract when it comes to ascertaining parties' rights and obligations? I mean, you referred to paragraph in the preamble, but how are we to be guided by something that is not crystallized as a clause in a contract?
I think what the preamble does is evince the contracting party's intentions. And why the intentions are relevant is because Yam Seng and Ng Gyap Hon both really emphasize the contextual nature of good faith. So any duty to be implied really depends on what the parties are intending. So in this case, the clear aim is mutual equitable profits, mutual respect and trust. So what I'm arguing is that the relationship is only mutually beneficial insofar as both of them can profit. And since my client has found other ways to profit, in this case, it doesn't violate good faith by pursuing alternative partnerships. It's not undermining the contract. All it's doing is rigidly adhering to the terms, right? So I think that's the relevance of the preamble.
On that score, you know, we are actually, counsel, not impressed by your clients. Because you say on the one hand that they conducted themselves in accordance with business practices and so on, but yet if you look at the present case and paragraph 11 of the judgment in particular, your clients were found to have hidden their partnership with other competing distributors, and nothing short of a lie that they were encountering production limitations and difficulties. So surely this is a case where a doctrine of good faith has to be introduced to at least bring some semblance and hold your clients to account for this conduct, to say nothing of the fact that supply was diverted to two rival distributors, resulting in an increase in price, and clearly they benefited from this unconscionable conduct. And if you look at Yam Seng, that seems to be the sort of situation where this court will be minded to impose implied duty, good faith, whether in law or in fact. What do you say to that?
Sorry, before I answer the question, given that it's time, may I ask for another minute to answer the question?
Oh, please take the time you need.
Thank you, Your Honor. So what I understand from what you said is that my client's behavior appears to be unconscionable. But to answer that, first, I'd like to emphasize that Tabat J himself acknowledged at paragraph 26 of his judgment that there was no evidence of outright misconduct nor misrepresentation by my client, and it's not for the court in this present instance to dispute the facts. Secondly, according to the principles of Yamsing, I would argue that what my client is doing is would not be considered commercially unacceptable. I also like to emphasize again, there's no exclusivity clause. And while perhaps what my client has done is not allow the profits of the respondent to increase, they refuse to increase the prices nor the supply. But I like to point out that this is not an obligation of my client. My client has been increasing the prices in the past out of goodwill and willingness to pursue the contract because it was commercially viable. And in fact, forcing my client to continue doing so would be quite unreasonable. There's no obligation of disclosure. My client never lied. All my client did was to pursue alternative means. And I would submit that that it's important to look at the alternative, right? And it's important to allow flexibility in this case, which my client exercised.
But it was your client that drafted the JVA, isn't it? So why are you complaining about the deficiencies of that arrangement when clearly it was created by your client's in-house counsel?
Counsel, apologies. Your 1 minute is up. Perhaps you could address this issue during your rebuttals.
Thank you.
Thank you, counsel.
Well, I think we proceed with the senior respondent.
Okay, could I just do a quick audio check?
Yes, you can be heard.
Okay, great. I'll begin my submissions in 3, 2, 1. May it please your honor, I'm Priyansh Shah, counsel for the respondent Moshengren Private Limited, and I'm joined by my co-counsel Chantal Ying. I'll be taking on the first ground of appeal on the doctrine of good faith, and she'll be taking on the second ground of appeal regarding unconscionability and economic duress. At this present juncture, I would like to check first that your honors have a copy of the written submissions.
Yes, we do.
Yeah.
Counsel.
Okay. And I would also like to check at this juncture that your honors are sufficiently well-versed in the case facts and as well as the precedent authorities, such that we may proceed through the written submissions without much further delay.
I've always wondered what if we said no to that question.
In that instance, I would be forced to explain further in summary.
No, we won't trouble you. Can you proceed, please? Thank you.
Okay, thank you, Your Honor. So, the respondent submissions come in 3 main tranches. Firstly, with respect to the precedent authority in law for the implication of a duty of good faith. Secondly, with respect to the policy benefits and implications of such an implication. And thirdly, with respect to the factual circumstances of this present case. Now, if I may direct you to submissions 1 and 2 on my written submissions, we first make out the case for the precedent authority that exists for a duty of good faith to be implied either in law or in fact, and especially the latter in this particular case. And on this point, it is submitted that there is sufficient precedent authority for 3 main assumptions. Firstly, that there is authority for a duty of good faith to be implied in Singaporean law, and that this is available to the courts, and the courts are competent to be able to find this authority. Now, this can be found at Ng Yap Hong, paragraph 97, on page 111 of the bundle. Secondly, the fact is that the implication of duties of good faith, or duties even more onerous than good faith, such as like fiduciary duties, or duties amounting to certain good faith practices, like a duty to act honestly or a duty of cooperation, have been implied by the courts in Singapore, and therefore the concept of implying a duty of good faith is nothing new to the Singaporean law landscape.
Actually, counsel, maybe we can just cut to the chase. Can you cite us clear authority where the Singapore courts have in fact implied a duty of good faith into a contract in Singapore?
So
yeah, can you
so
cite me
that's
yes. Can you cite me Singaporean case authority to that effect?
So, Your Honor, the fact of the matter is that there is no case authority in which a duty of good faith has been implied. However, in the case authorities of Ng and in the case authority of the One Suites, it is left open to judges to be able to imply a duty of good faith in fact where it is found to be reasonable to do so. And additionally, in the case,
sorry, so is
yes.
Sorry, and is that the test laid out by the courts where it is reasonable to do so? Because those were your words.
No, sorry. The test that's laid out by the courts within Ng at least is where it would be necessary to prevent some wrongdoing on part of one of the parties within a particular sort of relational contract. Does that satisfy?
Yep, okay.
Okay. So with respect to the implication of a duty of good faith in fact, lastly, we'd also like to make the point that under the One Suites, Justice Fang mentions that at the next possible instance where duty of good faith may arise in a particular contract, it would be a good time to clarify the doctrine within Singaporean law. So we submit that this is just such a time.
So you would agree that prior to this, that I mean, whilst there appears to be some recognition that there may be a need or there may come a time where such a duty is implied, that there is some degree of uncertainty as to the scope of any such doctrine. Right? That would be fair to say. Would you agree?
Yes, it is agreed that there is presently some uncertainty as to what a duty of good faith would entail specifically. There have been certain, like, especially if we look at, again, the judgments in Ng and the One Suites, which are heavily relied on this submission, there is some understanding that, like, in the event that a duty of good faith would be implied by the courts, at that period of time, the courts would be able to clarify fully and conclusively what a duty of good faith in Singaporean law would entail. Now, there have been certain authorities like Yam Seng in English law, which set out certain principles that may be incorporated into a duty of good faith, such as honesty and fidelity to bargain. And as well as if we look at the case of the One Suites itself, where they discuss the duty of cooperation, it's implied in that judgment that the duty of cooperation would also be a substantial part of a duty of good faith in Singapore. So while there are principles on which to build this doctrine, there currently is not a clear doctrine. But that is precisely why the Court of Appeal in this present case should take this opportunity to establish this clear doctrine that can be used in future cases with future clients. So if that satisfies, I would like to move into some policy submissions.
No, before you go there, Counsel, the difficulty we have is that we do not see that clarity in the trial judge's findings. I think the only paragraph where he appears to have touched on this is in paragraph 25 and I suppose 26. And it appears the trial judge appears to have relied on is the cause of conduct between the parties, which spanned 10 years. That appears to be the only consideration that the trial judge appears to have taken into consideration. And I would like to hear your thoughts on
that. Your Honor, would it be possible for you to repeat or rephrase the question?
Yeah, so I mean, I think we started off this discussion on the basis that in the earlier case law, the courts have said we can possibly imply such a duty of good faith, but there needs to be greater clarity. I suppose the theoretical foundations and structures of the doctrine need to be more settled. And we now have a situation where a trial court or the court below appears to have made that finding. And we're trying to understand how the judge below went about making that finding. What were the factors he looked at? And it appears to us that the only things he appears to have relied on is the fact that these were contracting parties that have done business with one another for an extended period, 10 years, and they are in some sort of a symbiotic relationship. Is that sufficient? I mean, are those factors determinative of any finding? That is where I'm coming from, Counsel.
Okay, thank you, Your Honor. So with respect to this present case, it is accepted that one of the main considerations that Justice Tabat takes into consideration is the nature of the relationship itself. And he seems to rely on, Yam Seng and the decision by Justice Legat regarding the nature of a relational contract. And this seems to be what he's described in the present verdict. Now, this, of course, establishes the basis upon which a duty of good faith can be implied, that there is a contract for which this would be possible to do. But additionally, I think it's worth recognizing that the basis of the implication of this duty of good faith, in fact, within this particular case, is really the conduct of the appellants, and the conduct of the appellants was found to breach principles of good faith, especially considering those of like honesty and of course fidelity to bargain, again referencing Yam Seng. At this juncture, I realize that I'm out of time. I would like to ask for an extra minute just to wrap up submissions.
Yes, please go ahead, Counsel.
Yes. So it comes back down to the facts of this case. It is clear that Justice Tabat has recognized that there is a relationship of trust and a relationship of mutual reliance between the two parties, and this is also reflected in the preambles of their own contract, in which they mention acting with good faith towards each other. And this relationship of trust is precisely the key to the duty of good faith that must be implied, in fact, in this case, because the trust has been broken. Quite simply, if we look at the conduct of the defendant, talking about being deliberately kind of cagey with the truth, talking about being strictly commercial in a relationship that had been clearly much more goodwill invested, etc., it's clear that the trust that existed between the appellant and the respondent had been broken. And for this breakage of trust and the ensuing losses, there's clearly a right to a remedy for the respondent that has to be respected. And I think this is the basis on which Justice Tabat made his decision, and that is what we should uphold in the Court of Appeal today, because to do anything else would be clearly unconscionable. Thank you. For these reasons, we find that the appeal should be dismissed.
Thank you, Counsel.
I think rebuttals.
Rebuttals?
Come at the end, right?
Apologies. Rebuttals will be taking place at the end, so after the junior respondent has spoken.
Okay, so
Okay,
then we'll
thank you.
we'll move on to hear from the junior appellant then, please.
Yeah, can I just check that I am audible?
Yes, you are.
Okay, I'll begin shortly. May it please the court, I am Tan Tai Cheng and I appear for the appellant. The second issue on appeal is whether the actions of the appellant were so unconscionable as to amount to economic duress. To that end, I will make three submissions. Firstly, that Singapore does not recognize the doctrine of economic duress. Secondly, even if the doctrine was recognized, that Tabat J had incorrectly applied the test. And thirdly, that the appellant had applied mere commercial pressure and not economic duress. Firstly, the test applied by Tabat J is not recognized in Singapore. What was the test applied by Tabat J? At paragraph 27 in his judgment, the test for illegitimate pressure was whether the appellant's actions were, quote, so unconscionable as to amount to economic duress, citing Tam Tak Chuen. However, this test faced strong opposition in the case of EC Investments 2 years later, which stated at paragraph 49 at page 804 of the bundle that the definition adopted in Tam Tak Chuen, quote, should not be adopted without a great degree of caution, unquote, emphasizing that it comes too close to rewriting disadvantageous contract. The concern is that equity may be measured by the length of the Lord Chancellor's foot, which is precisely what has been done when Tabat J supplied subjective judgment for what constituted unconscionable action, even when reasonable minds could differ. In fact, at paragraph 66, page 810 of the bundle of EC Investments, the court held that they, quote, did not think unconscionability as a vitiating factor in contract forms any part of Singapore law, unquote. They explained that such a doctrine would inject unacceptable economic uncertainty into the law. And unlike other cases, this was ratio of the High Court of Singapore, which we are not apt to depart from. And they have stated in no unambiguous terms that there should be no place for such a doctrine in Singaporean law. Secondly, even if economic duress was recognized in Singaporean jurisdiction, Tabat J had still applied the wrong test for illegitimate pressure. Having read the respondent counsel's skeletals, it appears that the respondents are also somewhat confused with the test for economic duress. I will begin by clarifying the law. What constitutes illegitimate pressure? Opposing counsel correctly points out that paragraph 52 at page 805 of the bundle of EC investments provides a list of factors which the court should take into account, which includes whether there was a reasonable alternative and whether actions were made bona fide. The emphasis on the words take into account means that these factors are factors that the judge should consider, but are not actually the determinative test for illegitimate pressure. Which means that even if there is no reasonable alternative, that does not necessarily mean that there is economic duress. So, what is the general test for illegitimate pressure? There are two cases which I will cite which outline the overarching principles. A. At paragraph 250 in page 919 of the bundle, in the case of Jong vs Sumito, the court distinguished mere commercial pressure from economic duress. They defined duress as, quote, deliberate exploitation with a view to gaining some advantage unrelated to the contract and to which he is not entitled. B. At paragraph 64, page 809 of the bundle, in EC investments, the court cites special disability as a test for unconscionable bargains. The court defined special disability as poverty, old age, or ignorance at the same paragraph. The special disability test is reaffirmed by the recent case of Times Travels versus Pakistan International Airlines at paragraph 24 and 85. In the
Actually,
yes?
you're taking us through the law. That's very helpful. But can I perhaps just take a step back and have you share with us what is it that the respondents are complaining about as being unconscionable at your clients' end? What is it that your clients did insofar as the addendum to the contract, which they say was unconscionable? Let's break that conduct down.
So if we look at the judgment, Tebat J says that what was unconscionable was the brief time span, i.e. the 3 months of notice that was given to the March 2022 lease agreement. We will argue that this is actually not a test for, this does not satisfy the test for unconscionability, because number one, we would posit yes.
Counsel, put aside the test for now. Just take us through the conduct that is being complained of.
So the conduct that is being complained of is the increase in price for the lease of the appellant's storage facilities. Yes. May I continue?
Is that it? Is that all that is being complained about?
Well, yes, that is primarily what is being complained about, because the claim of economic duress is directed towards the 2022 lease agreement, which is why the complaints are confined to this area, which is the lease agreement alone. So if we go back to the overarching principles, we think that the test has not been satisfied in this case because, first of all, there was no special disadvantage. You cannot be argued that the respondent was in any way poor, ignorant, or of old age, nor was there any advantage taken off that was beyond the scope of the contract, right? We think that furthermore, there's not even an undermining of good faith, because previously the appellant had actually been charging the respondent 20% below market prices. In fact, what the appellants had done in this case by increasing prices by 25% is to bring the prices they charge back to market level. Your Honor, we will posit that it is unfair to impose a duty on the appellants to continue to subsidize the cost of production of the respondents, and we think therefore the claim for economic duress should fail. Which brings me on to my third point of submission, that both Tebat J and the respondents had failed to distinguish between economic pressure and commercial pressure and economic duress. So how do we distinguish between illegitimate economic duress and legitimate commercial pressure? The core authority is paragraph 97 at page 1010 of Times Travels, which states that commercial self-interest is justified. It goes on to say at paragraph 98 that any lawful threat backed by commercial self-interest is legitimate. How does this apply to the present case? As I've already explained, it is within this commercial self-interest of the appellants to raise prices back to the market level. There is no reason why the appellants should continue to subsidize the cost of production of the respondents. This falls squarely within the realm of commercial self-interest and is therefore not duress. Secondly, opposing counsel asserts that the appellant knowingly exploited the reliance on the joint venture. This was in their skeletals. Nowhere in the facts is it stated that the appellant's intention was anything more than commercial self-interest. We cannot decide cases on the basis of hearsay and on facts that were not decided. Thirdly, I will posit that there's a strong legal conundrum with the bona fide factor. In the contract, there are no requirements for the termination clause, and there's no requirement for the appellant to continue to extend their services to the respondent in spite of their reliance. We think in the present case, if the appellants had just not renewed the contract, there would have been no claim of economic duress, which would arguably have been worse for the respondents. It would be a paradox to find that not renewing the lease would in fact not constitute economic duress, whereas renewing the lease somehow would constitute economic duress, when clearly renewing the lease is much better than not renewing the lease. Fundamentally, there is a contradiction and a paradox in the application of the law of economic duress, and we think that such unclarity has no place in Singaporean contractual law. We think the respondent's claim should be struck out and the court should fine for the appellants. Yes. And for that, I rest my case.
Can I ask you a question? And this is something that I think you can assist us by your answer. And that is in relation to the doctrine of economic duress versus the doctrine of unconscionability. You did make some brief reference in your arguments to how the learned judge may have gotten it wrong in terms of confusing these two tests. How would you crystallize the doctrine of unconscionability as acting and being applicable in this case, as opposed to the non-application of economic duress as a doctrine? Are we looking at the same thing?
Okay. May I first? I'll assume that I have permission to go on for another minute, so I'll answer that question. The doctrine of economic duress is intricately connected to the doctrine of unconscionability. And to that, I will cite paragraph 50 of Tam Tak Chen. Paragraph 50 of Tam Tak Chen defines what is illegitimate pressure, and in subsection D, it defines one of the factors of economic duress as whether or not it is unconscionable in the light of all the circumstances. This is why the doctrine of unconscionable bargains is intrinsically tied to economic duress, because it is one of the core factors. And yes, therefore, the doctrine of unconscionability in this case was sort of drawn in an equivalence with the doctrine of economic duress by Tebat J. Therefore, I think it is fair to use both of them interchangeably in this context. Is Your Honour satisfied with my response?
Not entirely, because I do find that one is a more indeterminate and non-fungible creature, as opposed to prescriptive criteria that can be applied to the doctrine of economic duress. How would you address my concern?
I think I'm out of time. Perhaps I will address that in my rebuttals.
Very well.
For that, okay.
Yes, but don't forget to address it. Thank you. Junior respondent. Good morning.
Okay, may I check that I'm audible?
Yes, you are.
Yep.
Okay, thank you. I'll proceed with my written submissions in a moment. Okay. Your Honor, my name is Ms. Chantal Ying, and I appear as counsel representing the respondents. Following the response to the appellant's first ground of appeal addressed by my co-counsel, Mr. Priyansh, I will now be submitting my arguments in response to the second ground of appeal. I submit first that the appellant's conduct did amount to economic duress, and secondly, that to uphold standards of conscionability in economic relations is vital for matters of policy. The counsel for the appellants argued that the actions of their clients merely amounted to commercial pressure. But from one glance at the facts, it is apparent that the duplicity and backhandedness of the appellants very much forced the respondents into a corner wherein their only viable choice was to succumb to a deal, hence falling within the ambit of economic duress. The guidelines for this doctrine may be found in the case of Tam Tak Chen, being firstly, pressure amounting to a compulsion of the will, and secondly, being the illegitimacy of the pressure exerted. In paragraph 22 of the case, pressure is illegitimate where the terms secured are so manifestly disadvantageous to the complainant so as to make it unconscionable. This is clearly applicable here, given that every new term laid out in the addendum was ostensibly unfavorable to our clients.
Counsel, surely these new terms would have, your client would have run them by their legal representatives as they did at the time the original JV agreements were being negotiated. But why was that not done in this particular scenario?
I briefly go through this in my following submission, but I will argue that this did not occur in this instance because the manner in which the appellants introduced these changes were very much such as to overwhelm the will of our clients. There was a confounding number of new terms that was presented to our clients at once after a period of minimal communication and without any apparent opportunity for negotiation. In this case, it was quite clear that there was an implicit pressure that was applied on our clients, that the appellants were not prepared to give a lot of time for the respondents to mull over their options.
Yeah, but your clients could have gone back to say one of two things. One, they could have said these terms were not acceptable, or two, they could have gone back to say not acceptable, but this is what we counter propose. None of that was done on the facts.
I would actually argue that this shows that there was indeed economic duress, because the first element of economic duress is a compulsion of the will. So we would submit that the respondents' instant acquiescence to the new terms in the face of no viable alternative strongly suggests that this was the case. They did not even think to negotiate the terms further, because their will was so much overborne that they felt they had to instantly acquiesce, in contrast to a very measured and fairly negotiated deal.
Was there evidence to actually show that the instant acquiescence, as you say, was as a result of them feeling overwhelmed? Was there any evidence at the trial below to indicate that?
From this, we could only necessarily infer from their behavior. I would argue that as seasoned businessmen, they would understand the natural goings of contractual negotiations. But in this case, because they were at one point a top distributor in that space, so it's not as if they are like a particularly naive businessman. However, in this case, the number of new terms and the real lack of alternate route strongly suggests that their will was so much overborne that they felt the need to acquiesce immediately without even going back to their own legal counsel. So,
well, counsel, another way of looking at it is that your clients actually foolishly signed up to a bad bargain and are now trying to get out of it. And hence this rather contrived argument of economic duress.
I would not argue that I submit that this was not a case of our clients signing up to a bad bargain, as they signed up to the bargain at the terms that they signed up to the bargain initially in the start of the contract was very, very different from this sudden 180 degrees that the appellants have very much sprung on our clients. It is
counsel. So I see where you're going. My point is they could have simply gone back to say, sorry, this is really you changing the goalposts, and we are unable to agree, and so on. But they did nothing of that. They agreed. They signed off on the new terms, and are now coming before the court to say that they were under some form of duress. How do we make any sort of determination if there was no pushback on the terms on the ground to begin with?
To this, I would submit that indeed it was in the immediate instance that there was no pushback, but it would be due to in the heat of negotiation. I would argue that we don't always make the most measured decisions. And this would actually support our argument that in this case, it wasn't a fairly negotiated deal, that the calculated manner in which the appellants introduced these changes was such as to get acquiescence from our clients as quickly as possible. In the case of Tam Tak Chen at page 776, the fact that there was that the appellants did not explicitly pressure our clients into immediately signing is not conclusive. If there's an implicit pressure that they are not ready to give our clients time to mull over their options, that could also vitiate their consent.
Counsel, you have not really identified disability as such. I mean, you're asking this court rewrite what you would consider to be an improvident contract, where things are done for commercial interest, that of itself does not amount to economic duress. But we are also right to say, are we not, that there is no identified special disability, such as the normal factors like what was stated in our module, poverty, ignorance. I mean, your clients are commercial men as well. How do you address us on that?
I would submit that in this instance, it's not a typical special disability as those listed out, but I would argue that the omission of truth on the parts of the respondents very much put our clients in an especially disadvantaged position, because their clients had full knowledge of the circumstances of the respondents, wherein our clients had no knowledge that they were diverting supply to two rival distributors while also allowing them to charge higher prices. They also misled our clients into believing there were production difficulties. So it was very much a case of our clients having very minimal knowledge of the true circumstances of the transaction, in contrast to their clients' full knowledge of all of the circumstances. So I would argue that this would put them in an especially disadvantaged position. Additionally, in the case of EC investment, the courts do take a multifactorial approach to assessing illegitimacy. I note that my time has currently run out. May I have an extra minute to wrap up my submissions?
Yes, finish your point on EC investment.
All right. In the case of EC investments, the courts take, as I said, a multifactorial approach to assessing illegitimacy. And in the case of Go Bilan, it is held that the totality of the conduct should be considered, including that in the lead up to the signing of the addendum. In this case, the appellant's purposeful withholding of information, misleading statements, and general lack of good faith, as elaborated by my co-counsel, trapped our clients such that they could only acquiesce to the new terms. When there is no real choice afforded, that is not merely an inequality of bargaining power, as the learned counsel opposite have tried to frame it, but very much illegitimate pressure that would constitute economic duress. For the interest of time, I would conclude my submission here. If Your Honor has no further questions, that will conclude my submissions.
Thank you, counsel.
Thank you.
Thank you.
Rebuttals?
Can we just check whether the senior appellant or junior appellant will be delivering rebuttals?
I can raise hand.
Just raise your hand. Okay, understood. Thank you.
Okay, thank you. Just quick check. Am I audible? A quick thumbs up would be all right. Yeah, okay. I'll begin in a bit. Okay. On the first ground of appeal, I would first like to make quick reference to one of the questions offered by the court. The question was, how should we interpret the vagueness of the terms of the contract? At this point, it is worth noting that there was a more detailed version of the contract that was offered, but that was rejected in favor of a more vague contract. The correct interpretation of this is that the parties rightfully wanted to have flexibility in the contract, and therefore they applied more vague terms which did not bind them to any specific obligations. And that flexibility was the flexibility which was precisely exercised by the appellants. There was no term of exclusivity, and therefore the contract was not intended to supply the benefit of exclusivity. There is no obligation for one contracting party to subordinate its commercial interest to the other. But more importantly, it is worth emphasizing the fledgling nature and the high threshold that must be established before a finding of good faith can be implied. In fact, we think the respondents have failed to prove this threshold, or to prove that there was any sound footing for the law of good faith in the law as it stands, and we think the court should find in favor of the appellant. Second ground of appeal. The question posited by the court was whether was between the doctrine of economic duress and unconscionability. One is clear and the other is not. Two things. First of all, it is worth noting that EC Investments recognizes that perhaps there is an established role of unconscionability in the realm of equity. And we precisely agree. If equity is able to provide a remedy for unconscionability, the law of economic duress should be discarded as redundant, especially since it is so unclear. Given that the respondent should have brought a claim in equity in order to evoke the doctrine of unconscionability. However, that was not what they did. They brought a claim in contract, and we think therefore the law of economic duress should not be given any relevance in this case. But secondly, I would posit that there's in fact not much legal clarity. The legal clarity only applies to the case of lawful act duress. Tam Tak Tran is not analogous to this case because Tam Tak Tran involved the abuse of legal process, whereas there was no abuse in this case. Proud to propose.
I think your time is up.
Okay, Ethan, are we good to go?
Yes, we are. When you're ready, you can do the honors.
Okay, cool. Thank you. Thanks, Ethan. Okay, guys, we have all the speakers back in, and as you know, both myself and Stanley, we were in a breakout room earlier where we were deliberating on the result. Thankfully, we're not here to deliver judgment on the appeal. We're here to decide the winner of the final round, and I think the decision is unanimous. Having heard all the speakers, we think, or rather, our decision is that the appellant team wins it. Right. So, congrats to the appellants. Okay. Fortunately, we're on a virtual setting, so we don't hear a round of applause and all, but yeah, well done, guys. Okay, so now that we've announced the winners, we thought it'd be useful for us to give you guys some broad feedback. Stan, okay if I went first?
Why don't you kick off and then I'll chime in after that.
Okay, cool. So we're just going to give general feedback to the speakers. I think generally we thought both teams performed well. We know that in law school, it's different, right? This is where you're sort of picking mooting up as a skill, and you'll get better with practice. And our job is to give you some pointers which we think will help you along the way. So one of the things that I noticed was the good signposting at the onset. All of you, when you were starting off your submissions, you sort of broke it down into the various points you were going to be making to advance your arguments. I think that's always very helpful. Helps the judge look out for the points that you're going to be covering. I thought what was good was for the opening speaker, for the respondent, you didn't just introduce the arguments that you were going to be making. I think you also introduced your co-counsel and the arguments that your co-counsel was going to be making. I thought that was very helpful. There was a issue about whether or not the bench should be taken through the facts, and I think counsel for the respondent, the first counsel, senior respondent counsel, I think you started off by asking the bench as to whether or not we should be taken through the facts. And then Stanley asked you, what if we said we would want to, right? You probably spend half the time allocated to you taking us through the facts. So I was going to say that there perhaps is a slightly more elegant way of going about it. Instead of plunging into the submissions proper, it's always very helpful to sort of kickstart your submissions with a 30-second or a minute sort of summary of the factual position of factual case. It's always good if you can sort of summarize in under a minute what your case is about factually. This case is about this. And as respondents, we are going to be making arguments on this issue and that issue. So that way, you're sort of getting the judge up to speed on what the factual scenario is. The judge may have read it. If he has read it, then 30-second or 1 minute spiel is sort of going to refresh his memory on things. If he hasn't read anything, at least it gives him some context. And obviously, how each of you introduces the facts will somewhat vary, right? I mean, the appellants might spin it somewhat in a way favorable to themselves, and the respondents might do that separately as well, right? You're not sort of misrepresenting things. I'm just saying the way you spin it in that minute or so is helpful, all right? So that's something to sort of take note. You don't want to plunge into your submissions and assume the judges are completely au fait with the facts. They may not be. They may not be. All right. So I think that's something you want to note. I know we're doing this moot virtually, and there's a time limit, and all of you are trying to ensure that you cover all the ground that you have in the 8 minutes or so. The result of that is sometimes you tend to be too fast in delivery, right? And I think that was very, very apparent for us because we're trying to catch up. And so sometimes you might have found that there were some periods where we weren't really asking you questions, but that was largely because we're trying to catch up to what you were saying. I was trying to take notes as well and all. But it is what it is. We are mindful of the fact that you've got very limited amount of time as well. But that's a point you want to bear in mind as well. Your delivery, the pace of your delivery is important, all the more in a open court setting where you are in person and making arguments. You want to be measured. You want to take time. You want to ensure that points register with the judge. So you really need to watch your pace as such. Respondents, when you are making submissions, do not forget that you are respondents for a reason. So that means you must actually be responsive to the arguments that the appellants are making. You're not just making arguments in a vacuum or in isolation. You need to be responsive to the argument. So, for instance, the first speaker for the respondent, I know I think I gave you a hard time in terms of questions that I was posing to you. But what I would have liked, for instance, was to see, for instance, you dealing with arguments like the appellant saying, look, there was no exclusivity clause in the contract. And because there was no exclusivity clause in the contract, how is it that we're now slapped with an implied term of good faith? So it would have been nice to say, look, we heard this from the appellant. These were the arguments they made, and this is what we want to say in response to it. All right. It helps sometimes to actually reference it in that way, rather than leaving it to the judges to listen to your submissions and realize that you are actually responding to something that the appellants have said. So it's always good to reference something that was said, and then take the bull by the horns and say, this is why they are wrong, and this is why what we say should hold water with you, the judges. All right, so takeaway is respondents, you need to be responsive to the arguments that are being made as such. One small point about citing of authorities. Again, for me, I'm not necessarily impressed by the case paragraph page number of the authority. There is a way you want to cite authorities, right? If you want to bring a case to the judge's attention, you cite the case, you then cite the general proposition. If there's some particular paragraph that you want to draw the court's attention to, then you want to say things like, Your Honor, this is a particular authority that I would like to bring Your Honor's attention to. It's in the bundle before, Your Honor. And there is, there's something relevant in the case that I do want to bring Your Honor's attention to. If I can trouble Your Honor to turn with me to tab whatever, and if Your Honor can then look at page 1 of this authority and this particular paragraph. Now, this is where the learned judge says this. All right. So there were many occasions where you guys were rattling off paragraph numbers and page numbers, assuming that the judges are going to be flipping and so on. They're not going to be doing that. But again, as I said, I'm mindful of the fact that, in the limited time that you have, you're just trying to ensure or show that you have a good command of the law in support of your position. But again, this is feedback not just for the purposes of this moot, but moving forward as counsel, there is a way of ensuring you bring authority to the judge's attention for maximum impact as well. Okay. Small point about eye contact and hand gestures. Sometimes when we're doing hearings virtually, we overlook or rather, we forget that it's equally important to ensure eye contact with the judges. I was trying to ensure that I was looking at the speakers as they were making submissions. There were a number of speakers who were distracted. Some of you were actually looking up as you were making submissions and not looking directly at the judge. You might get away with that in open court in-person setting because it's a much larger setting. But in a Zoom setting where we have the speaker pinned, we can actually see everything zoomed in, right? So you need to be extra careful in remote or virtual hearings, including things like hand gestures as well. You know, if you tend to get very animated and so on, that can be distracting to the judges as well. So it's something to watch out for. One thing about the facts, right? I know you guys are running with the facts that you have here. You just need to be careful about extrapolating from the facts or making facts up. That's something as counsel you almost certainly never want to do. If you are hamstrung by the facts, you just need to acknowledge it and say these are the facts that we're dealt with, and we're trying to make the best arguments on the facts. You do not want to try and make assumptions or, as I said, extrapolate the facts to make good on an argument that you are trying to advance. Small points, rebuttal. I think Stanley had allowed you guys to address some of the questions from the bench as part of rebuttal, but that's not common, right? What actually I was hoping for was for there to be some serious rebuttal to be dealt with first before coming back to deal with the question which wasn't fully answered in the course of the submissions. What we saw instead was, I think the speaker who handled the rebuttal actually using the time to address both questions that came up in the course of the original set of submissions. So I know, as I said, that's something we said, please come back and deal with in rebuttal. But I was hoping that, you know, there would be actually substantive rebuttal before those questions were addressed, perhaps for some indulgence for more time to deal with those questions, right? So, but that's something I thought I will bring to your attention as well. But overall, as I said, we see a lot of potential in all of you. All of you must continue this journey, and you will only get better with more and more practice as well. That's it from me.
Yeah. Thanks, Ramesh, and thank you all. I think it was a very, personally, I found a very didactic session. All of you made very good points. I think if you look at the mooting as a skill set, I mean, certain things can be carried into litigation in practice, and one of them is actually a certain track that judges will take in addressing you. So Ramesh and I didn't actually coordinate or discuss the appeal beforehand. But if you notice, the way our questioning of the speakers went, Ramesh was very anxious to look at the judgment and ask counsel to address paragraphs of the judgment. Now, that speaks actually to a point that counsel should always start with, and that is, look, what did the trial judge get wrong? I mean, you got to, in the first 2 minutes, nail that down in any appeal. If you're the appellant, it's incumbent on you to do so. And if you're the respondent, you got to be equally convincing in saying what he got right. And that's something that would speak and sink, stay with the appellate court. So that's one point. Now, if you look at the way I was approaching the questioning, I was basically testing the respondent's submission skeletals against the appellant's arguments, but I was not doing it so obviously, but I did ask you points. So that actually zeroes in your preparation quite significantly when dealing with a time allocated appeal hearing. So plan accordingly, because you have judges approaching the whole issue of the appeal differently from different perspectives. And it's actually the big ticket items that you got to deal with at some point. So the big ticket item was really doctrine of unconscionability. How does it elide with economic duress? Not the same thing in my view, but I think that's a factor that will go on. You can quote Andrew Pang and saying the next good faith case must be dealt with clarity, but why do you assume that is this one? That's a point that we may not have been necessarily impressed that this was the case to actually get into that animated discourse. So I thought you should either side should make use of what is actually commented on by judges in other judgments, which I thought some of you did, but I think on balance we thought that the appellants, I think in terms of delivering pithy statements of the law, which do make more of an impact than you think in moots, but also I dare say in real life as well, in litigation. So that is one general point. When looking at pithy statements, disability points, that clearly is a point that you needed to confine rather than to expand, because if you expand or even to suggest that the categories of disabilities are not closed, that gives us a greater difficulty not to find duress, you see, because we're looking for prescriptive criteria. The court is always looking for prescriptive criteria for future application. More uncertainty, more fact-specific inquiries are not useful. Also, in the context of appellate court litigation, increasingly more dangerous to just confine us to the facts found below. That I would suggest is not the most encouraging start. Mustn't assume that the appellate court will not relook at the facts. Even though no matter what the case law says, I think as a matter of instinct, you have to satisfy the judge's curiosity first, regardless of what your understanding of the law is. So that's just a tip for the future. I dare say, especially in Singapore court litigation, you will find appellate intervention on factual matters and evidence quite apparent. But overall, all of you must be congratulated, and I hope that when you're back in Singapore, please look us up. I mean, not for moot. I mean, to me, that's socially. It'd be very nice to speak to all of you and to find out what's going on in the UK. Are there any questions you may have for us? You have to unmute yourself.
I think apologies, if any of you want to unmute yourselves, could you just raise your hand and we will ask you to unmute.
Hi, yes.
Hi, yeah, on the note of these statements, I think it would be a bit more instructive if you could give an example of, say, a pity statement that was issued in this moot and how it influenced your judgment.
No, I think your delivery of the principles and the way you did it in relation to cases without going into chapter and verse, but I think the only thing that I think I speak for Ramesh as well. We found you a bit too anxious and angsty in the speed of your delivery. But I think if you just took a step back and basically slowed down by a millisecond, actually, you actually got to the point. And I thought what was interesting in dealing with rebuttals, you actually addressed the question I had between unconscionability and economic duress. Although we would have preferred it if you took it up at the main hearing. I mean, when you were dealing with your substantive appeal, rather than go to rebuttals, because the court needs to hear a response quickly and a rebuttal quickly to its own questions. You don't want a judge mulling over a point because the point doesn't go away. In fact, it stays there and it'll come back to haunt you even worse later on when you deal with it. But just look at your own delivery, measure the pace, and I think it was good. I mean, you were obviously anxious. I mean, you drank that big gulp of water in front of the court, which is
Twice,
fine.
actually.
Sorry.
Twice.
Yeah, twice. But actually, in court, especially in Singapore, there's certain judges who really will eschew that behavior. Drinking from the bottle is one thing, drinking from a cup is another, and etc. So you will learn all this, like, when you get into the trenches with the rest of us, right, Ramesh? Yeah.
Yes,
There'll be
absolutely.
plenty of time to.
There was one point that there was a point that you made that I particularly liked, and I thought that could have come out perhaps earlier in your submissions. I think you were trying to say, I think in just the point that you were making is that we're dealing with a renewal scenario, right? The lease could not have been renewed, right? We could have chosen not to renew the lease. Instead, we gave them the option of renewing it. They took it up and are now trying to allege duress, which is absolutely ridiculous, right? I thought that sort of hit home with me. I thought that was very persuasive, and that's examples of key points that I think you can try to score with the bench. I mean, that's very relatable. You got to try and see how you weave it in the course of your submissions as well. I think that came up in response to a question that I think Stan had asked you, and it was responsive to that. But I thought that was a good point, and it could have been weaved in as part of your submissions so yeah, that's just a short point.
I think when I asked the senior appellant, when I said, not asked, but when I said we're not impressed with your clients, usually when a judge says that, the cue that counsel needs to make is, you have to really address it and basically say, look, I don't disagree. You may find the practices sharp and on occasion not necessarily principled, but that of itself will not lead to the consequences that the respondents are asking. You see, so that is the way to address the point. It's okay, because your duty is owed to the court, so you will find yourself in practice in situations where you do not feel that you have to defend your client to the nth degree if it does not help your argument, especially a legal argument. Now that's a matter of judgment that will come with time, and not without a few lumps and bruises along the way. But I suppose that's what litigation is like. But overall, you keep it up. I think you're on a good, you're on a good trajectory. So please keep this up and continue, because this only gets better with practice. Yes, that's a question.
Yes. So this is just a short one. I feel like we are starting to perhaps take too much of your company. But with respect to the I guess priorities, because obviously the time constraint in this moot has been quite short. I think 8 minutes it's the shortest that I've ever worked with. And I think that generally moots tend to be a bit longer, but regardless, there's always going to be this whole aspect of time. In these time constraint scenarios, what really is the priority? Now, we mentioned talking about like the brief layout of your case. We talked about, giving like kind of summary ideas of the cases that you refer to, and of course the policy and fact documents that you're going to make in the moot. So what's the priority? If I say I have, like in this present scenario, 8 minutes, and I know that there's going to be judicial intervention, what do I start with?
Okay, so I can tell you that having participated in international moots myself, where I've been in a situation where I'm into only my first argument, and I'm getting a whole barrage of questions from the bench on that first argument, and I know my time is running out, I can tell you that it is a skill in itself to actually, or rather, let's put it this way. If you complete your time without actually going into your second and your third arguments, that's going to count against you, right? Yes. Because one necessary skill of an advocate is time management, right? So I think it is important to also watch the clock whilst you are dealing and fielding the questions that are being posed to you. If you see that you are running out of time, and you have not yet moved into your second or third arguments, it is important for you to remind the judge that that is the case on the ground. You've got to say, Your Honor has asked me this question. Allow me to answer this question. But Your Honor, there are two further submissions I need to make, and it may be that I will have to seek Your Honor's indulgence for an additional 2 or 3 minutes of time in order for me to make those arguments. Or you can say, after you've answered the question, that in the interest of time, Your Honor, I will move to briefly touching on my second and my third arguments, but given the shortage of time, I will deal with them in summary fashion so that Your Honor is up to speed on the precise arguments that the respondents intend to raise or argue. So the takeaway for you is that time management is on you, the advocate, right? You cannot put it down to the bench to say, I got a tough time, or rather I had it hard on the first submission, and all of my time was exhausted on the first argument, and therefore perhaps I should be assessed on how I dealt with the first submission alone. No, doesn't work that way. It's on you, it's your responsibility to ensure that you make the most of the time that you have, which means keeping an active watch on the time and on the clock yourself. Yeah.
I mean, the thing I would add is, I mean, even from your submission just now, if you remember the way you structured your skeletals on the general duty of good faith as implied in law, and in fact, you notice that most of your time was spent on law, and actually you sort of brought in the implication in fact into the argument, but you didn't really have time to canvass many of your points. That's the consequence of having too many subtopics. In fact, what I found actually, your third point on setting a precedent of a duty of good faith, whether implied in law or in fact, was nothing more than than a welcome rationalization. That maybe should have been the first point, and then that would have led you to economize on the other two grounds and work within a general theme, because that's within time constraints. That's what you're looking at. You don't have time to deal with implication in law and then in fact, and then whether the it's good for precedent. That's just one.
Okay, thank you. Thanks so much.
Thanks. So I think, yes, hi.
Hi, sorry.
More the questions than the actual mood itself. Yeah. That's fine.
Thank you for the feedback. I actually want to build on what the senior respondent's question on time management, because I noticed that both in my like our side skeletals and their side skeletals, we had policy arguments. So I guess I have a broader question on like what's the best way to bring in policy arguments, and when do you think it's appropriate to do it? Yeah.
I think honestly, policy arguments should never be made at the expense of factual application, because at the end of the day, it's the law in relation to the facts. Where the policy arguments help is to fashion our curiosities as an appellate court on what direction the law needs to take. And so, I mean, subject to what Ramesh thinks, I think your first point is really to say, what did the judge get right or wrong? Which is the complete basis of your appeal, and say that, because I've been in appeals where sometimes the court will ask, well, I've heard you for half an hour. What was actually wrong with what the judge held? So that tells you actually you actually didn't convey that at the very start, which is actually the most important point. So that's important to bear in mind. It's a matter of judgment always. Too much policy and then it sounds too much fluff. You got to get into the nuts and bolts and the findings. What are the special factors? Any special factors? Get into that, and where does it? So you notice Ramesh also was asking questions. So where is this in the evidence? He wants to know. What were the judge's findings that would match and complement your argument? Ramesh, I mean, please add to this.
Yep, I would agree.
Yep. So in that case, in the interest of time, I fear some of our participants and or judges might need to leave. To sum up, on behalf of the UKSLSS, thank you A&G for supporting us throughout this moot, especially Lei Feng for organizing, who I believe is still in this room. To the 4 participants and to the winning team as well. Congratulations on making it this far, and I hope that at each stage of the competition you managed to get constructive feedback first from some of our more junior student judges and younger associates, and then as you progressed into the subsequent oral rounds from more senior lawyers. And I hope that all of you have grown from the experience. I'm not sure if I mentioned it expressly, Stanley and Ramesh, but this is actually a first-year moot. So our aim was to derive which was the best first-year mooting team out of the Singaporeans in the UK. So I suppose now we have our answer. And of course, to our 4 finalists, your prize is an internship at A&G. So if you do have any more questions, I'm sure Ramesh and Stanley will be very happy to see you in the office when you go. So one last thing before we end the call for today, we'd just like to take a group photo. The participants, if you could add your name, your own names next to your junior appellant, and then we can take a screenshot for social media. Lei Feng, if you'd like to turn on your camera, you can join us as well. Oh,
yeah.
Okay, no worries then.